Mental Hygiene Law, Article 911, Patient's Records. Except as to informal patients and patients admitted pursuant to Sections 939 or 940, the director of a hospital shall, within 5 days excluding Sunday and holidays, 5 days excluding Sunday and holidays, only Sunday and holidays, after the admission of any patient, forward to the Mental Hygiene Legal Service a record of such patient, and shall is simultaneously forward to the department such information from the record as the commissioner by regulation shall require. Such information from the record in the department shall be accessible only in the manner set forth in Section 33.13. A hearing demanded by the director to involuntarily retain a patient who initially entered the facility voluntarily must be set by the court, Supreme or County Court where the hospital is located, not later than 3 days from the date such notice has been received by the court. The notice shall be fixed by the court, shall be at a time not later than 3 days from the date such notice has been received by the court. If it is determined by the court that the patient is mentally ill and in need of retention for involuntary care and treatment in the hospital, the court shall forthwith issue an order authorizing the retention of such patient for care and treatment in the hospital, or if requested by the patient, his guardian or committee, in such other public, non-public hospital as may be within the financial means of the patient for a period not exceeding 60 days from the date of such order. What the? Okay, 913, voluntary admissions. The director of any hospital may receive as a voluntary patient any suitable person in need of care and treatment who voluntarily makes written application thereof. If the person is under 16, so that's 0 to 15 years of age, the person may be received as a voluntary patient only on the application of 1. The parent, 2. The legal guardian, 3. Next of kin, 4. Social service official or authorized agency with care and custody of the person as per Social Services Law 384A, 5. The director of the Division for Youth, and 6. A person or entity having custody of the person pursuant to an order issued pursuant to Section 756 or 1055 of the Family Court Act. If the person is over 16 and under 18, which to me seems like it would just be 17, but I don't know why they wouldn't just write 17 then. Okay. The director may, in his discretion, admit such person either as a voluntary patient on his own application or on the application of that list that I had before. 1. The parent, 2. The legal guardian, 3. The next of kin, 4. Social service official or authorized agency with care and custody, 5. The director of the Division for Youth, or 6. A person or entity having custody of the person. Okay. Can you stop talking? Thank you. If such voluntary patient gives notice in writing to the director of the patient's desire to leave the hospital, the director shall promptly release the patient. However, if there are reasonable grounds for belief that the patient may be in need of involuntary care and treatment, the director may retain the patient for a period not to exceed 72 hours from the receipt of the notice, and shall either release the patient or apply to the Supreme Court or the county court in the county where the hospital is located for an order authorizing the involuntary retention of such patient. The application and proceedings shall be in the manner prescribed in this article, except that notice of such application shall be served forthwith, and if a hearing be demanded, the date for a hearing to be fixed by the court shall be at a time not later than 3 days from the date such notice has been received by the court. If it be determined by the court that the patient is mentally ill and in need of retention for involuntary care and treatment in the hospital, the court shall forthwith issue an order authorizing the retention of such patient for care and treatment in the hospital, or, if requested by the patient, his guardian, or committee, in such other non-public hospital as may be within the financial means of the patient for a period not exceeding 60 days from the date of such order. Further application for retention of the patient for periods not exceeding 6 months, 1 year, and 2-year periods thereafter, respectively, may be made in accordance with the provisions of this article. In the case of a patient under 18 years of age, such notice requesting release of the patient may be given by the patient, by the person who made application for his admission, by a person of equal or closer relationship, or by the mental hygiene legal service. Okay, and then it says, if such notice be given by any other person, the director may, in his discretion, refuse to discharge the patient, and in event of such refusal, such other person or the mental hygiene legal service may apply to the Supreme Court or to a county court for the release of the patient. 915 says, such person may be admitted as a patient without making formal or written application thereof, and any such patient shall be free to leave such hospital at any time after such admission. So that's only with involuntary admissions. Now we have voluntary and informal admissions, the suitability of it. In order for a person to be suitable for admission to a hospital as a voluntary or informal patient, like, why do we need to know this stuff? Why do we need to know this? Okay. All right, let me go back to this. All right. In order for a person to be suitable for admission to a hospital as a voluntary or informal patient, or for conversion to such status, he must be notified of and have the ability to understand the following. 1, that the hospital to which he is requesting admission is a hospital for the mentally ill. 2, that he is making an application for admission. And 3, the nature of the voluntary or informal status as the case may be, and the provision governing release or conversion to involuntary status. Okay? And B, the department shall have the power. Ooh, this is a good question. The department shall have the power to examine the patients admitted pursuant to this section and determine if they belong to the voluntary or informal class. Any failure to conform to the requirements of this section shall be considered a sufficient cause for revocation. 919, voluntary and informal admissions, notices. The director shall cause all patients admitted as voluntary or informal patients to be informed once during each 120 days of hospitalization of their status and rights. That's once within 120 days. Once within 120 days. Okay. There was another 120 days. The director shall cause all patients admitted as voluntary or informal patients to be informed once during each 120 days of hospitalization of their status and rights, including their right to avail themselves of the facilities of the mental hygiene legal services. At the time of such periodic notification, the written consent of a patient to his continued stay as a voluntary or informal patient shall be attained, and a copy shall be given to the mental hygiene legal services. 921. It shall be the duty of all state and local officers. Oh, this is voluntary and informal admissions and encouragement of voluntary and informal admissions. That's what it actually is. Okay. A, it shall be the duty of all state and local officers having duties to perform relating to the mentally ill to encourage any person suitable to... Oh, man.